So our next panel is on labor union political activism. This panel is going to explore the impact of increased union political activity that was briefly talked about this morning, and whether restrictions on that activity are warranted. So our speaker today is my esteemed colleague, Alex McDonald from Littler. Alex is a co-chair of the Workplace Policy Institute, and he is a prolific writer on this topic and other topics that are mentioned here today. So Alex, I'm glad you made it. And our commentator is Alan Klinger. He's the chair of Steptoe & Johnson's Labor Practice Group, where he leads the firm's representation of public sector unions and employee benefits funds. So with that, Alex, take it away.
Should I stand up there?
Whatever you're comfortable.
Need a little bit. Sitting for a while. All right. Well, thank you so much. I'll get the headline out of the way that this talk is about whether exclusive representation, which is really one of the fundamental principles in labor law today, is consistent with what the Supreme Court has said about the freedom of association in recent years. Okay, Mrs. Lincoln, how was the rest of the play? I actually think they gave me this slot to make Roger and Sam sound more reasonable when they start talking about turning the NLRB into a court. Just to take a step back, the genesis of this talk was actually another paper that I wrote that was based on another paper that Sam Stryker wrote, which I heard about at another conference. So this is a little bit like, labor conferences eating their own tail. We're in this giant Ouroboros. So what ended up happening was I had gone to this other conference, and I'm listening to the leader of a major labor union give a talk, and she's speaking about some of the political activity her union had been involved in. And I'm not using her name because I think the tagline of that other conference is that what happens there stays there. But I think I can say that Professor Stryker stood up in the middle, and he asked this president of a major labor union about political activity they'd done, and he mentioned a concept called voluntarism. I confess, I knew at the time I had heard of voluntarism. It wasn't something I was deeply vested in. It wasn't something that they taught in law schools. It's not something that comes up a lot in daily practice. And so I asked Professor Stryker about it afterward, and he mentioned that he had written a paper, and I read the paper. And after reading the paper, I realized that a sense I had had for a long time, nothing I could have articulated before reading the paper, but that it was true, and that there had been an evolution in the labor movement writ large. And the evolution was this: the labor movement was no longer only representing its members at the bargaining table. It wasn't just doing the day-to-day, sitting down and collectively bargaining and administering the contract and running grievances. In fact, it was also, and in some ways mainly, representing its members in the State House, in Congress, engaging in political activity. And something had happened to the labor movement over the course of the 20th century that it had transformed from a private, voluntaristic movement into what could fairly be described as a political movement. And that's important not just as an interesting social phenomenon. I mean, in and of itself, it's interesting to study, but it's also legally significant. In part because the Supreme Court in recent years has said repeatedly, and in some context, in the labor context specifically, that forced association with an expressive group, a group that is engaged in proliferating a political message, in and of itself is a First Amendment problem. So let's actually take a step back, because this involves two different trends over the course of the 20th century, the evolution of the labor movement and the evolution of the First Amendment, which frankly, by 2020 was a very different piece of the Constitution than it was in the pre-World War II era. Starting with the labor movement, it's interesting, it's almost hard to see the evolution from where we stand today because we've gone so far down the road. When you say that the labor movement is engaged in politics and engaged in representing its members in a political context, that almost seems obvious to people now. But at the turn of the 20th century, that wasn't obvious. In fact, it was anathema to the labor movement's theme, to its calling card. And look, I understand. I actually want to give a caveat here. When we're talking about the labor movement, The labor movement is not monolithic. Different unions are engaged in politics at a different level, at different, at locals, at the national, et cetera. So, we're talking in broad terms a little bit. But to the extent there was a theme of the labor movement in the early 20th century, it was voluntarism. And voluntarism was associated with Sam Gompers, who was the longtime president of the AFL. Gompers had some experiences early in his career. He had been involved in an effort to get these regulations passed on manufacturing cigars in tenements in New York, here actually. He got that law passed, but it was ultimately overturned in the courts. And the lesson that Mr. Gompers took from that experience was that the labor movement would never really be secure if it was relying on the government, if it was relying on courts, that it had to stand on its own feet and draw its strength from its members through voluntaristic action. That sounds nice in theory. It was what he really believed in, but it runs into some practical problems. And one of those problems is, you may not pay attention to courts, but sometimes they pay attention to you. The unions were engaged in voluntarism was both cooperation and direct action when cooperation didn't work. And when unions engage in direct action against employers, often the response is that the employer would go to court. So I've actually never seen an authoritative count of how many labor injunctions there were in the early 20th century. I know William Forbath did a count in a book a couple of years ago that put it at something like 4,300. But whatever the number was, it was a lot, and it was growing over time, and it was also getting more potent because in the 19th century, a lot of these labor injunctions were issued under the common law. There were conspiracy doctrines where, employers would go to court and they'd say, well, you're engaged in this conspiracy to raise your wages. But that had sort of lost its teeth by the turn of the 20th century. There were cases like Commonwealth v. Hunt where the court said, no, this is not actually a conspiracy. This isn't a problem if a couple people get together and agree we're going to act together to raise our own wages. So you're casting around for new theories if you're trying to get a labor injunction. And one of those theories might be drawn from a new statute at the time called the Sherman Act. The Sherman Antitrust Act. There's some debate about whether the act was intended originally to apply to unions, or as the act was being drafted, there was a labor exemption put in and then taken out. So, take from that history what you will, but what we do know is that the Sherman Act was applied to unions early and often. And there was a series of cases where the courts were not only enjoining unions under the Sherman Act for alleged, effectively cartel activity. What they were doing is treating unions as a combination to restrain trade, essentially a labor cartel, and then enjoining the unions from engaging in activity or direct action and imposing damages. So the Sherman Act has treble damages, right? So you pay whatever the employer lost as the result of your collective action plus 3 times that number. And that ends up going up to there was a foundational case sort of reached its apex in a case called Lowe v. Lawler. It was the Danbury Hatters case, where the court said, yeah, you can actually, not only does the Sherman Act apply to labor activity, but you can hold individual union members and officers liable for these treble damages. Now that's if you're a union, that's a existential crisis. Now, every time you engage in this direct action, which again is part of the fundamentals of voluntarism, you're looking at treble damages. You just can't do it anymore. And so what the unions did, the labor movement did the only thing it could do, which was loosen its insistence on voluntarism. Sam Gompers himself went to both parties. This was initially a bipartisan effort and asked for relief from these labor injunctions. The Republican Party ignored him, but the Democratic Party responded. They responded with things like the Clayton Act, which created a labor exemption under antitrust law. When courts read that narrowly, they responded with the Norris-LaGuardia Act, which prevented courts from issuing some of these injunctions. They responded with the National Industrial Recovery Act, which for the first time put into statute the right to collectively bargain. And ultimately, they responded with the Wagner Act, which is what we now know as the National Labor Relations Act, or at least the foundation of it. And what the unions learned from this experience was that politics perhaps wasn't a forbidden fruit, but a magic elixir. Because in the 10 years after the Wagner Act is passed, labor membership in America goes from less than 4 million to more than 13 million. It's like a shot in the arm. And so many in the labor movement think, well, if this works so well, why should we shun politics? And in fact, many of them didn't. The history is complicated here, more than we can get into in the time we have, but there are moments along the way. There's the formation of COPE, which is the AFL's political arm. There's the reunification of the AFL and the CIO in response to the Taft-Hartley Act. There's Ronald Reagan breaking the air traffic controller strike. There's a surge of political spending in the labor movement in the 1990s, all of which gets you to the point where by 2020, labor unions are spending almost $4 billion every election cycle on politics. I mean, it's $1 billion a year. They're one of the biggest donors in America. So the labor movement has a very strong political bent to it in modern society. So that's one side of the story. The other side of the story is the First Amendment. Again, this history is complicated, but in the post-World War II era, the court starts leaning into individual rights, some of which stem from the First Amendment. This is partly a speech story, right? So think like Barnett, the fixed star in our Constitution is the government cannot say, what is a doctrine in or orthodox in politics. But part of it is an association theory. So association
Alex, if I can, before you go more into associational,
Absolutely.
which is interesting, on the first part that you talked about, in terms of, I think we can all stipulate that labor unions are spending a lot of money on elections, lobbying, and and thank you for your paper, because it sort of opened up new issues. But isn't the same thing happening in the corporate world? Sam moderated a program a couple months ago here that was entitled Corporate and Union Political Activism. I don't know if part of this came up this morning, but the professors there spoke about the fact that there's a tie, that one of the professors, Kovali, said there are genuine economic links between political issues and the interests of workers or shareholders. He went on to say, political positioning is oftentimes a valuable strategy or tool for delivering economic benefits. If you're seeing that this is a problem for reasons, associational interest in the union sense, wouldn't there also be one in the corporate sense? Because you have shareholders, of corporations. They don't necessarily agree with, and I think we can also stipulate that corporations, businesses, in the aftermath of Citizens United, is spending a ton of money on doing the same thing, perhaps 180 degrees, that the unions are trying.
Yeah, I think that's an interesting point. And one thing you might hear, let's say we have the stand-in for the labor movement, this person standing here, they're going to say, well, we have to do this, right? If we're not engaged in politics, we're not at the table, and it's unilateral disarmament. Because of course, the corporate world writ large, again, which is not a monolith, is engaged in politics. Both sides are. Of course, that's true. And there may be instances in a corporate context in which you might have a situation where somebody is required to associate with a corporation. It's a little bit different because we don't have the statutory mandate of exclusive representation, which we're going to get to. But yeah, I mean, to some extent, unions don't really have a choice about whether they're going to do this. Either they don't engage in politics, or they're going to get their lunch taken from them in the State House. So it's not as if somebody has made a choice. Well, we could be voluntaristic and not spend any money on politics, or we can change our whole identity and become political organizations. I think this has happened organically, and it has happened in response to movement that you've seen. I'll call it the other side, right? Again, this is not a clear V, but it's I mean, some of this is not by choice. This is by necessity. So from the First Amendment standpoint, I'll try to speed this up a little bit. We get to, there are cases like Boy Scouts v. Dale more recently, and before that USJCs, where the Supreme Court starts to articulate a view of associational rights under the First Amendment that includes not only the right to join groups that express messages, but also the right not to join groups that express these messages. And in the labor context, this starts to take real valence in cases like SEIU v. Knox and Harris v. Quinn, where the court starts to take a more aggressive view of the First Amendment in respect to labor issues. And it reaches its climax in Janus in 2018. I'm not going to spend a lot of time on Janus because I'm sure 99.5% of people in this room are very familiar with Janus. The takeaway there is that the court says that agency fees in the public sector are unconstitutional under the First Amendment because bargaining with the government is political. And what you're effectively doing is forcing somebody to fund a political activity. Agency fees, again, are just the fee that a non-member has to pay for bargaining expenses. So that case was about agency fees, but Justice Alito, writing for the court, also had some words for exclusive representation. He's responding to an argument on the other side, and he says, it could be a throwaway line if it wasn't Justice Alito writing it. He says that, exclusive representation is the kind of burden on associational rights that we wouldn't accept in other contexts. He doesn't actually say we do accept it in this context. He just says that it's a burden on associational rights. And that line, that one line in Janus, sparks a whole cottage industry of litigation against exclusive representation in the public sector. There are dozens of lawsuits over the next 5, 6, 7 years. That wave has now crested, and I'll tell you the result has been a little anticlimactic. Most courts to address the issue have said, well, we can't get to this question because there's an older Supreme Court case called Knight v. Board of Community Colleges of Minnesota that blessed exclusive representation in the public sector. And because Knight blessed exclusive representation in the public sector, even though there's this tension now with Janus, we can't actually get there as a court of appeal. And the Supreme Court has not taken this case. I won't belabor the point. I think some of those decisions are overreading what Knight actually found. But here's the point for the purpose of the paper in this talk. Knight's logic was this. The exclusive representation, though that wasn't actually the issue in Knight, could be fine because all you're really doing is, as the state, is choosing your own bargaining partner. Right? The state has no obligation to listen to anyone else. It can choose to bargain with anyone it wants, and so if the state, acting as employer, chooses to bargain with only one person, that's not a burden on anybody else's First Amendment rights. They can go out and say whatever they want in some other forum. So let's just stipulate that's what Knight stands for. That doesn't actually translate to the private sector, because in the private sector, the government is not picking its own bargaining partner. What the government is doing is inserting a bargaining agent between two people who would otherwise like to bargain with themselves or between themselves. There's an employee in this scenario that wants to bargain directly with the employer outside the collective bargaining process, and there's an employer who would prefer to do it, and then there's a statute that says the union actually stands between them. So Knight doesn't really have anything to say about private sector bargaining. Okay, now the next objection is, well, hold on a second. The very basis of Janus was that bargaining in the public is political, right? And that doesn't apply to the private sector, right? We're just talking about a private contract. Well, if you agree with the first part of the analysis we just walked through, that the labor movement writ large is now a political entity first, then this all of a sudden becomes a First Amendment problem. And Knight isn't standing in the way of reaching this issue. So that was a lot to get to that point. There are 3 objections I hear to this really commonly every time I talk about it. And the first one is, Alex, you're just a management side hack. Isn't this just union busting? Right? You just don't like unions. That's why you're talking about exclusive representation. I mean, and what I try to answer that objection with is another question, which is how has exclusive representation actually worked out for the labor movement up until now? For a generation, it's been the most controversial part of labor law. It's often the first thing that people who don't like unions go to. It's like, well, you're forcing somebody into this monopolistic relationship. Why can't they choose to bargain for themselves? So it's a reputational burden. And what do you get for that burden? Well, you get to deal with things that courts make up, like the duty of fair representation, where you have to represent people who don't want your representation. You have to represent them in right-to-work states, even if they're not paying you a dime. That's a burden. And frankly, it hasn't propped up the labor movement's numbers. I mean, today, we have a private sector that has 5.9% of workers who are in a union, which is less than when the NLRA was passed. So I'm not sure that exclusive representation is doing a lot for unions, and maybe if it wasn't there, you would have more incentive to innovate and less of an inertia factor when you're just locked in by statute to representing the entire unit. The other objection I hear pretty commonly is, well, unions are different, right? You're saying unionism is political. Well, there's other unions that really are just engaged in the day-to-day work of representing their members and processing grievances and negotiating contracts. And to that I say, you're right? There are unions out there who are not engaged in politics, who are not making the face of their union some protest against some foreign war. They are really just about representing their members. And to those unions, I would say, don't worry about it. This is not your problem. The unions that have to worry about this are the ones that are most engaged in politics and have made association with that union expressive, that you are associating with a political message. Those are the unions that are going to have to deal with this problem eventually because, look, this is America. Every question gets distilled into a judicial question eventually. So even though this hasn't been teed up for courts yet, it likely will. The last objection I hear pretty commonly is one that Sam raised the first time I told him about this paper, was well, how do you get around the state action rule, right? Because there are older cases like Street under the Railway Labor Act, which this was about agency fees, and the court said, well, we can't even address this under the First Amendment because this is a product of a private agreement. This is just a union and an employer agreeing to collect agency fees. And to that, I would say, well, this is different in kind. Yes, those cases are about the product of a private agreement, an agency fee, but exclusive representation is not the product of an agreement. It's the product of a statute. Right? The union has a statutory right to represent every employee in the unit, and if the employer tries to go around the union and negotiate with an individual employee, the employer faces statutory sanctions. The force of law stands behind this principle. And so there's clear state action in the context of exclusive representation. I'm almost out of breath because I've just been filibustering this whole time. I'm going to take a pause and sit down, and if we have time for questions, that would be wonderful.
Or Alan, you have further comment?
commentator.
Yes, so
Yeah.
here, one I'd like to say is that what I think you've just heard is the latest round of the frontier to disempower unions. And I understand, the issues it's coming from. But I'd like to start by saying what I think is a fundamental misreading of Janus, because that becomes the linchpin for the intellectual argument. Justice Alito knows how to invite people to bring cases to accomplish something. I submit that's not what he was doing in Janus for the issue of exclusivity. If you look at the decision, he explained that states can keep their labor relations systems exactly as they are. They just cannot force non-members to subsidize public sector unions. He also talked about the fact that it's not disputed that states may require that a union serve as an exclusive bargaining agent for its employees. Itself a significant impingement on associational freedoms that, as Alex said, would not be tolerated in other contexts. We simply draw the line in allowing the government to go further still and require all employees to support the union irrespective of whether they share its views. Now, I know some people have said that when he says it's not disputed, he means that it's not disputed in the case in the argument before the court there. But I don't see how that position really holds when you look at the rest of his statements in Janus about you can keep them exactly as they are. And I think the reason that it's different is that the Supreme Court in Janus and in other cases has said not all burden on associational interest is unconstitutional. It's really a balancing test analysis. And what happened in Janus is that 5 of the 9 said, you know what? This is to force someone to actually be making a payment, compelled speech there. That was too much of a burden on associational interest. The notion of exclusivity really arises from the desire to have labor peace, and that it goes back to the NLRA, a lot of Supreme Court decisions. My colleague Alex Langer is with me here. He introduced me to Emporium Capwell, a decision by Justice Marshall, accepting exclusivity, and in the case of rejecting a challenge there, that people wanted to be able to pursue, or Black employees wanted to pursue discrimination claims differently than the union. And it's probably not an accident that Justice Marshall was assigned the decision to write, but that he said, no, exclusivity is fundamentally important to labor peace. And yes, exclusivity is determined by a majority vote. If it's determined by a majority vote, that necessarily likely means that there are going to be some people within the union body, the worker body, that actually isn't agreeing. But you know what? That's our representational democracy. And I think that and the reason that I don't believe that this is an undue burden on freedom of association is because of the importance of having stable labor relations. Because what would happen if you didn't have exclusivity? And I understand the argument that Alex makes, that he's saying, well, how well has exclusivity worked for you? But I actually think it's worked for unions. I think it's worked very well for the system. And the reason I think that the Supreme Court would come out differently if this issue does reach them, where, as Alex indicated, they have denied cert, I think more than once on this, on this issue,
A dozen times.
is because for the agency fee, it was really about the union and whether the union was going to be subject to the free rider syndrome, that people could just not pay their dues, not pay anything to the union, even their fair share, and still get all the benefit. Okay? That was just for the union. But now when you look at what exclusivity does, is exclusivity, I submit, is both better for the union and for the employer. And so I think that's why a balance would come out differently there than what happened in Janus. And look, I'm not aware of any unions. I mean, unions, one of the price you pay for exclusivity is you have the duty of fair representation to all. So that the union has to represent the employees who are not members of their union just as well as they represent those that are. That's sort of the quid pro quo of it. And some people have said, well, maybe unions would prefer to be relieved of the obligation to represent people that aren't paying dues. I'm not aware of any unions that are jumping at that opportunity. And also, and I do think that history has shown that you do have more labor peace. And in fact, one of the points that Alex makes in his paper is that there have been strikes recently. I think the fact that a handful of strikes made such news was because it is so rare now, and I think because of the way the principles of the NLRA, the Labor Board, has developed, is actually what is preventing there from being war. And if you don't have exclusivity, and I'll wrap up and give Alex a chance, if you don't have exclusivity, what you could have is you could have like warring factions within unions trying to represent people in the same, under the same employer. And part of this is that you could have the fear of the race to the bottom, that they'll look for unions, the employers will look for the unions that actually will give them the best deal. I also think there's probably as legitimate a concern is what you also risk are some of the unions being far more confrontational in order to try and show their bona fides. And I just think that would be a disaster for orderly labor relations.
Alex, can I ask you a question? What about Beck rights? The Supreme Court held, in order to avoid a constitutional problem under the National Labor Relations Act, that there have to be rights of political dissenters that are in the union shop to object to certain expenditures. I have a problem, one aspect of Beck, that you have to resign union membership. I don't think that should be required. You could still be a Beck objector, in my view. But are those rights sufficient to protect the dissenters under current law?
Let me respond to both. I think those are both really thoughtful questions. I'll start with what Sam was saying. I mean, look, Beck is a complicating factor in this entire analysis because the premise of Beck is that, well, yeah, you can opt out of political expenditures, which suggests that bargaining expenditures in and of themselves in the private sector are not political, right? It is this political, non-political divide, and the only way you get to a point that the Supreme Court would say, well, now exclusive representation in the private sector is unconstitutional, is you would have to accept the premise that there's been some evolution, that when we were deciding Beck and we were looking at the labor movement earlier in the 20th century, perhaps it wasn't as overtly political, or at least perhaps in an individual case, if we were challenging representation by a specific union that had engaged in overt political context and made association with that union expressive, to use the Supreme Court's phrase, that changes the analysis. And so Beck in and of itself seems to stand for an alternative proposition, which is that just
I think Beck came down 15, 20 years ago. Roger, do you remember when it came down? It was a Brennan decision. It's not that long ago. 1988. Nothing's fundamentally changed. I mean, it seems to me, you have the argument from Janus, you may disagree with it, is that the public sector union is inherently political because they're dealing with the public employer on the other side of the table. They help elect the public employer. But here with the private sector, it's very different, it seems to me. And collective bargaining, I have a problem with some of the political activism that's out there because they think it's unrelated to collective bargaining. It's unrelated to contract administration. But most collective bargaining is not political. What makes it political? in your view?
From an associational standpoint, it is not, you don't opt out of the associational analysis just by saying that the entity that you're associating with also has some other
I
activity.
just don't see
right?
how far this associational right could go. I give money to the city of New York through my taxes. They do a lot of stuff I don't like, but they solve a public goods problem in part, and I don't think there's an associational claim there. I mean, you have to say a union is different than a government, is what you can say. I mean, that's what you have to say on some level, but it's not inherently political in the same way that the public sector union was in Janus.
Look, some of this is not math, Sam, but there is a tipping point where an organization associates itself so clearly in the public with a message that associating with that group is expressive. So the NRA has a HR arm, right? But joining the NRA has an expressive context to joining it, right? And if you are a labor union that has engaged in overtly political activity, has associated yourself with non-bargaining political, social, economic messages, about more oriented yourself around policy, then there does come a point where you are an expressive group and associating with that group sends a message. And under the Supreme Court's analysis, that would mean that you now have an associational burden if I am requiring you to associate with that group.
Okay, but you do acknowledge that the member can feel free to speak out for himself or herself against the associational view.
That's right. Of course they can, right? They can speak in some other context, but the idea is that in the context of being represented, they have no choice. They must speak through this.
Are you objecting to the fact they have to become union members? What if we adopt the approach I was suggesting earlier today? You have certain participational rights, but you don't have to be a union member. Union membership is not required. Is that what you're
Well,
objecting to?
you don't have to be a member today. It's you can't bargain for yourself. It's the exclusive bargaining aspect.
Isn't this chimerical and bargaining for yourself? These workers have voted for a collective representative. I mean, that decision's already been made through that process.
But
They
individuals
can't
have
bargain
not.
for themselves, otherwise they wouldn't vote for a union, I think. The union takes dues to bargain for them, otherwise they wouldn't vote for it.
Okay, let's open up for questions from the audience. Questions, anyone? Roger, I know you've got a question. Roger?
Roger,
So Alex, you and I have talked about be careful what you wish for in the context of some of these constitutional challenges to work. What's the alternative? So if your theory is successful, where do we go from there? When I was bargaining contracts on a weekly basis, I really wanted, in most cases, to have a strong union on the other side that could speak for the bargaining unit. So when we got a deal, we got a deal. That was it. So exclusivity, I think from an employer perspective, has some very positive consequences. So what's the answer if you are successful?
This is actually another common objection that you hear to the idea, which is, well, once we get rid of exclusivity, bargaining becomes unworkable, right? Because now we have a cacophony of voices in every workshop, 1,000 different requests for different agreements. How do we manage this process without an exclusive representative? And what I will tell you is non-exclusive representation, individual bargaining, is the rule in most workplaces in America. And somehow we haven't descended into chaos without having one union sitting on the other side bargaining for every employee. I don't expect that we would see a great deal of additional chaos by saying that individual employees could opt out of a collective bargaining agreement if they so chose to do so. I just haven't seen any evidence of that.
I just would hate to see us bargain by way of TikTok.
Additional questions? Okay, with that, gentlemen, thank you. Thank you very much.
Thank you.